Hi, everyone.
Hello.
How are you today?
Good. How are you?
Good. I'm just going to wait a few more minutes to see if anyone else comes,
Okay.
and then we can get started on the sales contract. That's what we're all here for today, right?
Yes, ma'am.
Okay, good.
Awesome. Thank you.
You're welcome. All right, so we'll get right into it. So today we're here to talk about the sales contract, and it's February 20th, right? February 20th at 2:02 p.m. So here in Alexandria, we have a parade, President's Day parade. So I am hibernating in my house, and my block is the last one before they all get blocked off. So I see all the people walking. Anyway, so when we talk about the sales contract, what's important to know is that everything must be contained in that contract, okay? So if you want a for information only home inspection, it needs to be in the contract. If there are other things your client wants, it needs to be in the contract, okay? So we talk about the four corners of the contract, and within those four corners of the contract, everything your client wants needs to be in there. And if there's ever a legal issue, the first thing the court's going to do is they're going to go and they're going to look at the contract and what's contained in it. If I ever have any questions or I get questions from other agents, the first thing I do is go back and reread the contract. You can't read this contract enough. You will not know every little nuance, and things may come up, and you honestly, you just have to go back to the contract and read it. So let me share my screen with the latest contract. And here we go. So here's the contract. This one was updated 1/22. There are a couple new nuances that I can go over. And so we're just going to start at the beginning. This sales contract is offered on, and we put in the date of the offer between, and the buyer's names are here, and the seller. And where you'll go to find the seller's name is in the tax records if it's not in the MLS, okay? Sometimes also you might want to double check with the county. So if you go into the county and you search real estate assessments, you can look up the different assessments for different homes based on their address. And that will give you the names of the owners of the address. So when I'm a broker, I'm not sure I told you that, from Alexandria. So one of the things that I do, the reason we ask you for those tax records in command is so that we can verify that the tax record says that the seller is the actual owner. Believe it or not, there have been instances where people who didn't own homes tried to sell them. So we're always double checking that. Collectively referred to as the parties who, among other things, hereby confirm and acknowledge by their initials and signatures herein that by prior disclosure in the real estate transaction, KW Metro Center, the listing brokerage, represents the seller, and another brokerage is the cooperating brokerage and represents the buyer. Okay, so this is where you're going to put the listing brokerage and the buyer brokerage. The listing brokerage and the cooperating brokerage are collectively referred to as the broker. So when you see the word broker throughout the contract, they don't mean me, Gina Baum, your broker in Alexandria. They're referring to the brokerage and this agreement. So the agreements that your buyers and sellers have are with the brokerage, and you are an agent of the brokerage, as I'm sure you know from your licensing classes. The listing brokerage and the cooperating brokerage are collectively referred to as the brokerage. In consideration of the mutual promises and covenants set forth below and other good and valuable consideration, the receipt and sufficiency of which are acknowledged by the parties agree as follows. Okay, so paragraph 1. Paragraph 1 is going to be where we identify the property. I like to always see 2 identifying factors in case there's something off about the address. So oftentimes what you'll do is put in the tax map ID and the legal description, as well as the street address, city, state, zip code. So again, if you refer to the tax documents, you will have a tax map ID. And next to that tax map ID will also be a legal description. So you can use that. I like to have 2. It just verifies we're all talking about the same property. Okay, so paragraph 2, now we're going to talk about the consideration or the price and the financing. So here is where you would write down in A, the sales price. In B, you can use a number, like if your clients say, oh, I want to put $100,000 down, then you would use a number here. Or if they say, oh, I want to put 20% down, then you can use just the percentage here. Or you don't have to use both. 2C, now this is very important. And the reason it's so important is because the financing contingency that you will use refers to specified financing. And what it's talking about in the financing contingency is this paragraph 2C1. What is the financing that you're specifying here? Okay, is it conventional? Is it VA? Is it FHA? Is it USDA? Is it something else? And so here you would write in the first trust, or if you did the 20% down payment, you would do 80% for the first trust. So the reason the financing contingency refers to that is because if at any time the buyer changes their financing, that contingency is no longer in place. Okay, so if ever a buyer wants to change their financing, they need to get an agreement signed by the seller that it's okay for them to switch from conventional financing to VA financing. If they don't have that agreement and they still want to switch, they just have to know that that contingency is no longer in place. Second trusts, we used to see this a lot. We don't see it as much anymore. People, when loans were a little easier to get, people would get a second trust for the down payment, right? So they would use the second trust for their down payment and the first trust for the rest. The other option here is seller trust. Now, the reason why this might be sellers might want to be the financier is a couple of reasons. Their interest rates may be lower now than they were, say, for currently for the current market value of interest rates. And if the seller is in a position, they may be able to offer, 4% or 5%, whereas the going rate is 6%. And maybe that's even more than they would have, if they're only paying 2 or 3%, and that they could make money off of that. If they didn't need the house to be sold, it's certainly an option that sellers would consider. I have a seller now who is looking into their interest rate and seeing what they have, because they too would consider seller financing. And if you have a lot of equity in a home, what it does is it distributes your gains over time. So you're not paying a huge lump sum in capital gains and taxes. So that's why it might be advantageous to a seller. So the total financing will go here. One thing you need to be aware of, we've had some agents get tripped up on this, okay? So the seller subsidy to the buyer, it's what the seller is willing to give to the buyer for closing costs. Some people have put a number right here, a 1 or a 2, and the listing agent didn't notice, okay? That is for sure a 1 or a 2. It's like, it's in the contract, you have to give it to them. And so some agents have been tripped up by that and had to come to the closing with, a credit to the seller because they didn't notice the 1% subsidy that was going to the buyer. So just be aware, make sure you look at all of these little lines and make sure you're not missing anything. Financing contingency, this contract is contingent, addendum attached, or is not contingent on financing. If this contract is contingent on financing, buyer will make written application for the financing and any lender required property insurance no later than 7 days after ratification. Okay, so lender application for financing. Okay, so a lot of times what we do when we're representing buyers is we get them pre-approved. That's halfway there to satisfying this requirement, right? So they want you to make sure that you're making application for financing. In most circumstances, the lender who has approved your buyer has all of their information. The application is made, and all they really need at this point is the contract. So the next step for your buyer is to check into property insurance. And as you know, we have someone we work with, Patriot Insurance, who will handle all the insurance needs for your clients. Buyer grants permission for cooperating brokerage and the lender to disclose to the listing brokerage and seller general information available about the progress of the loan application and the loan approval process. So when I'm a listing agent, I always give a call to the lender and say, hey, are we good? Can you make this closing date? I have had instances where, there's a holiday involved and the lender said, no, I can't make that closing date. There's a holiday involved. And, the buyer's agent just, people are writing multiple contracts these days. The buyer's agent just like copied and pasted a contract and didn't notice that the settlement date was so close. So it's always a good idea to just give the lender a call and say, do you have everything? What do you need from me? Are we good? Is this a good solid application that you have? This contract is contingent. Is contingent or is not contingent on appraisal. If this contract is contingent on financing or appraisal, seller will provide appraiser reasonable access for to property for appraisal purposes, okay? Reasonable access is a phrase that you're going to see often throughout the contract. Reasonable access, this one pertains particularly to an appraiser, right? So if there are 1, 2, or 3 appraisers that need to come, the seller is required to give those persons reasonable access. If this contract is not contingent on financing and or appraisal, seller will or will not provide appraisers reasonable access for appraisal purposes. Now, this is a new sentence in the contract. And the reason this was added is because many people were saying, you know what, we're going to get financing, but we're going to waive the financing because we know we're good. Our lender told us we're great, and we're going to waive the appraisal because we're not concerned we have enough cash if the value comes in a little lower to make up the difference. So we're going to waive the appraisal too. And however, they still may need an appraisal for their loan. So this is where that instance would come in, that the seller will or will not provide appraisers reasonable access for appraisal purposes. If you're waiving the appraisal contingency and yet your clients are still getting a loan, you're going to need to check yes on this. Does that make sense? If this contract is not contingent on appraisal, buyer will proceed to settlement without regard to appraisal. Okay, so no appraisal occurred, buyer is going to settlement. That's what would happen sometimes on a cash deal. They don't even get appraisals. So just know that. Seller and buyer authorize broker to release sales price to appraisers who contact them to obtain the information. Nothing in this sub paragraph creates a financing contingency not otherwise agreed to by the parties. Okay, it's just saying if there's no appraisal and yet an appraiser contacts them, they will give them the information, but that does not create any sort of financing contingency. Okay, paragraph G, very important here, and it's important because people who are going to reside in their homes get lower interest rates than investors. So the buyer will or will not occupy a property as buyer's principal residence. Unless specified in a written contingency, neither this contract nor the financing is dependent or contingent on the sale and settlement or lease of other property. Okay, so 2 things here. The buyer's going to occupy the property or not occupy the property, and not occupied would be for an investor. And this contract is not contingent on the sale of another property. This is another sentence that was added because people were waiving their financing and yet they had a property to sell. And they knew if the property didn't sell, guess what? They weren't going to get financing. Well, this sentence was added so that people couldn't do that they would have to be actually upfront. Oh, yes, I do have another property that I need to sell. Buyer acknowledges that the seller is relying upon buyer's representations, including without limitation, the accuracy of financial or credit information given to seller, broker, and or lender by the buyer. Okay. Paragraph 3, deposit. So a lot of times, first-time home buyers might be a little confused about the deposit versus the earnest money deposit. Okay, so in this paragraph, we're going to be talking about the earnest money deposit. Okay, that's usually 1 to 3% of the sales price, and it's considered like the buyer's skin in the game. The higher that amount, the more skin they have in terms of getting this contract to settlement, right? So they have a bigger commitment. Buyer's deposit in the amount of X, check, bank wired funds, and or by note payable on will be held by, and as you know, we work with a couple title companies. One is MBH and the other is Universal, and you would put those here. So one of the reasons you might do a buy note, okay, is because there are people who are writing multiple offers at this time, right? And so if you keep writing checks and sending them to the settlement company and then losing the property and their checks going back and forth, it gets a little redundant and annoying for the buyer. So that is one of the reasons why you might be doing it by note, which would be payable on, you could say, ratification. That's the easiest way to do it. Just so you know, well, I'll get to that in the next sentence. Buyer has delivered deposit to escrow agent or will deliver deposit to escrow agent by, and this has to be 3 days. That's our office rule. 3 days after ratification. If buyer fails to timely deliver deposit to escrow agent as provided herein, seller may, at seller's option, deliver to buyer notice to void this contract. Okay, so our office requires that we get that EMD in within 3 days. The state law is 5 days. Okay. If it doesn't happen, then the seller is able to void the contract. Oh, by the way, if you have any questions, yeah, just jump in.
Okay, thanks. So right here, you said, unless we do by note, due and payable on ratification, then what would we put for the delivery date?
So you could put there 1 day, so because you're going to do it as soon as it gets ratified.
Okay.
Or you can even give it a couple days.
Okay.
That mostly refers to when you're gonna transition from a note to actual dollars, right? So you would do that on ratification and you would have 3 days to do it. So that would be fine too. Okay.
Okay. Thank you.
Sure. So in terms of the seller's right to void the contract, let's see, that upon delivery of the seller notice to void the contract, all respective rights and obligations of the parties arising under this contract terminate. Now, if the buyer hasn't delivered the EMD and let's say 7 days go by and the seller hasn't voided the contract, then the buyer may cure default by delivering deposit to escrow agent prior to the seller's delivery of notice voiding this contract. Okay, so if the seller never sends a void and the buyer 10 days later sends in their EMD, then the contract is in full force and effect. The deposit will be held by escrow agent into an escrow account in accordance with applicable state and federal law. This account may be interest bearing and all parties waive any claim to interest resulting from deposit. Deposit will be held in escrow until credited towards the sales price at settlement. All parties have agreed to, in writing to its disposition. A court of competent jurisdiction orders disbursement and all appeal periods have expired or disposed of in any other manner authorized by law. Okay, so once we get to a ratified contract and the EMD has been deposited, there are only certain ways in which that money can be used, and they're all specified here. Okay, so one party can't decide, oh, I'm not going to go through with this contract, I want my EMD back. Okay, it has to be both sides coming to an agreement or a court of competent jurisdiction ordering the disbursement. Okay. Seller and buyer agree that no escrow agent will have any liability to any party on account of disbursement of deposit or on account of failure to disperse deposit, except only in the event of escrow agent's gross negligence or willful misconduct. Seller and buyer further agree that escrow agent will not be liable for the failure of any depository in which deposit is placed, and that seller and buyer each will indemnify, defend, and save harmless escrow agent from any loss or expense arising out of holding, disbursement, or failure to disperse deposit, except in case of escrow agent's gross negligence or willful misconduct. Okay, so if the escrow agent steals the money, that's not the fault of the buyer or the seller. That's a different matter entirely. Paragraph 4. Now we're into when we are going to settle and perform on this contract. Seller and buyer will make first full settlement in accordance with the terms of this contract on or with mutual consent before, and here goes the date. Okay, so a lot of times I'll get calls from agents and they'll say, hey, we want to settle before the settlement date. Well, that's just fine. You don't, do I need an addendum? No, you don't need anything because it says on or with mutual consent before. So any date before this date is fine to settle, except as otherwise provided in this contract. If settlement days falls on a Saturday, Sunday, or legal holiday, then settlement will be on the prior business day. Notice to buyer regarding the Real Estate Settlement Act, the RESA, choice of settlement agent. You have the right to select the settlement agent to handle closing of this transaction. The settlement agent's role in closing your transaction involves the coordination of numerous administrative and clerical functions relating to the collection of documents and the collection and disbursement of funds required to carry out the terms of the contract between the parties. If part of the purchase price is financed, your lender will instruct the settlement agent as to the signing and recording of the loan documents and the disbursement of loan proceeds. No settlement agent can provide legal advice to any party of the transaction except a settlement agent who is engaged in the private practice of law in Virginia and who has been retained or engaged by a party to the transaction for the purpose of providing legal services to that party. Okay, so what that last paragraph is saying is that we can't use universal title or MBH if our clients need representation. They actually have to go to an outside source that practices real estate law and use an attorney for purposes other than settlement. So if there's some sort of disagreement. Variation by agreement, the provisions of the Real Estate Settlement Agents Act may not be varied by agreement. The rights conferred by this chapter may not be waived. The seller may not require the use of a particular settlement agent as a condition of the sale of the property. Okay, so this is something that came up recently. When the seller is using a different settlement company other than the buyers, it's usually just a matter of signing paperwork. It's not that they're actually getting separate representation. They are, however, allowed to pay for separate representation and have another agency handle their side of the closing. The Virginia State Bar issued guidelines to help settlement agents avoid and prevent the unauthorized practice of law in connection with furnishing escrow, settlement, or closing services. As a party to a real estate transaction, you are entitled to receive a copy of these guidelines from your settlement agent upon request in accordance with the provisions of the Real Estate Settlement Agents Act. So our both of the firms that we work with, they use a very protected site that that buyers will get a login to, and all of those things will be provided to them right there. And this is where the buyer will designate who their settlement agent is going to be. The buyer just designates MBH or Universal Title Settlement Agent. Buyer agrees to contact settlement agent within 10 days of ratification to schedule the settlement. Now, in all honesty, we've probably already contacted the settlement agent. Remember, we had to make application for our loan within 7 days, and we have to get in our EMD within 3 days per our office requirement. So the reality is we have probably already submitted our contract and have gotten this started and on its way by that 10 days. Settlement agent will order the title exam and survey if required pursuant to Virginia law. Settlement agent is sole agent responsible for conducting the settlement as defined in Virginia Code 55.1-900. Delivery of the required funds and executed documents to the settlement agent will constitute sufficient tender of performance. Funds from this transaction at settlement may be used to pay off any existing liens and encumbrances, including interest as required by lenders or lien holders. To facilitate settlement agents' preparation of various closing documents, including any closing disclosure, buyer hereby authorizes settlement agent to send such closing disclosure to buyer by electronic means and agrees to provide settlement agent buyer's electronic mail address for that purpose only. Now, when your buyer logs in to one of our settlement companies platforms, all of that will be taken care of. So you don't need to really concern yourself with it, except to say that the settlement company needs your client's email address. All right, so down payment. This is the down payment that they're referring to that will be, you know, in conjunction with the loan. So down payment will be paid on or before settlement date by certified or cashier's check or bank wired funds as required by the settlement agent. An assignment of funds will not be used without prior written consent of the seller. Okay, so bank wired funds, usually we know a few days in advance what the total is going to be. If there's some question about it, you can have your client wire an overage of amount, and then right there at the settlement table, our settlement companies will cut them back a check. Okay, so if there's any kind of error or there's, you know, anything changes or is a little bit different, they can get a check right there at the settlement table. An assignment of funds is something you should be aware of. So if your client is selling their house and they are, you know, settling on the same day, they're going to need an agreement for what's called an assignment of funds, meaning the funds from that closing are going to be used for them to buy the next house. Okay, the settlement agency will certainly help you do that properly. Delivery. Delivery in the contract is very important. It's going to discuss how we communicate with each other back and forth about matters of the contract, right? So this paragraph specifies the general delivery requirements under the contract for the delivery of the property or condominium owners association documents. See Virginia Property Owners Association Act and or Virginia Condominium Act paragraphs of this contract. So basically what they're telling you and not telling you here is that it's going to be different. So delivery for just general practices having to do with the contract, the delivery of different notices and things, general delivery. This paragraph is where you're going to look. If you have other issues with delivery in terms of the Property Homeowners Association Act or the Condominium Act, they're telling you right here, you have to refer to those paragraphs because it may be different, and it is. Delivery methods may include hand carried, sent by professional courier, by United States mail, by facsimile, or email transmission. So as you know, most of us now communicate by email. The parties agree that delivery will be deemed to have occurred on the day delivered by hand. Now they are defining when delivery takes place. Okay, it's very important. Have occurred on the day delivered by hand, delivered by a professional courier service, including overnight delivery service, or by United States mail with return receipt requested, or sent by facsimile or email transmission, either of which produces a tangible record of transmission. Okay, so it's telling you a couple things here. When you send something via email, go check your outbox, make sure it's in the sent box and it's gone, and that is your tangible record of transmission. So as soon as you press send and you verify that you have a record of transmission, that constitutes delivery. Okay. And so the reason that's important is if there are voids or there are things going back and forth and communications are missed. Okay, so that's why that's why they have defined delivery here. Deliveries will be sent as follow, addressed to the seller at property address unless otherwise specified below by, and you're going to pick one of these: United States mail, hand delivery, courier service, or fax or email. Check all that apply. If all of these are checked, it does not constitute delivery until you do all of them. Okay. If it's just email, delivery is made once you've pressed send and you've checked to see that you have a tangible record. Okay. And to the seller. So you're going to either put your name here, the seller's name and email address here, or both. Okay. So I usually do both. I want to know what my seller is getting, and I want to be a second check to them knowing that they've been delivered some sort of notice that is important for them to read about the contract. Okay. So the same here, you're going to be addressed by the buyer by United States mail, hand delivery, or courier service, or fax or email. Check all that apply. Again, the buyer here, and I always put my name there as well, because like I said, I want to know what's being delivered. This would be for like a home inspection report. It could be for a home inspection contingency removal. All of those things that come about because of the contract, this is what it's talking about in terms of how they'll be delivered. All right, the Virginia Residential Property Disclosure Act, as you know, for all of our buyers, we have a 4-page statement that we have them read. Okay, the Virginia Residential Property Disclosure Act requires a seller to deliver a disclosure statement prior to the acceptance of this contract, unless the transfer of property is exempt. The only time it's really exempt is when a trustee is selling a property because they have no knowledge of the property. So that's when it would be exempt. The law requires seller on a disclosure statement provided by the real estate board to state that the seller makes no representations or warranties concerning the physical condition of the property, and to sell the property as is, except as otherwise provided in this contract. Okay, so what that means is basically, as everyone knows, is Virginia is a caveat emptor state, and it means that the buyer needs to beware that the seller is making no claims about the house except that it's there and you can occupy it. Okay, so if there's anything that the buyer is concerned about, the buyer needs to do the inspections to be relieved of, you know, any concerns they may have. So here we are in paragraph 8 about the Virginia Properties Association Act. Again, this is going to tell us how we do delivery when there are association documents involved. The seller represents that the property is or is not located within the development that is subject to the Virginia Property Association Act. Of the act requires that the following contract language, subject to the provisions of subsection A 55.1-1814, an owner selling a lot will disclose in the contract that the lot is located within a development that is subject to the Property Owners Association Act. The Property Association Act requires the seller to obtain from the Property Owners Association an association disclosure packet and provide it to the purchaser. Okay, so if there's a homeowners association, the seller is going to have to get a packet and deliver it to the buyer. The purchaser may cancel the contract within 3 days or up to 7 days if extended by ratified real estate contract after receiving the disclosure packet or being notified that the association disclosure packet is not available. Okay, so the buyer has 3 days to review the packet. If you all agreed in advance that they wanted 7 days and we have an addendum for that and you use that addendum, then they would have 7 days to review the Homeowners Association Act packet. If they decide that what's contained in the packet is not for them, it could be anything, they do not need to disclose what matter it may be. They can void the contract with no penalty. to the buyer and get their EMD back. Okay. So the purchaser may cancel the contract within 3 days or up to 7 days if extended. I already read that. If the purchaser has received the association disclosure package, the purchaser has the right to request an update of such disclosure packet in accordance with subsection H of 55.1-1810 or subsection D of 55.1-1811 as appropriate, and the right to receive the association disclosure packet and the right to cancel the contract are waived conclusively if not exercised before settlement. Okay, so let's say the disclosure packet isn't as complete as you would like it to be, or that the buyer would like it to be. So the courts have ruled that it's the buyer's discretion then to void the contract. Okay, so you may get an incomplete packet, and it's the buyer's option then to accept an incomplete packet or to void the contract, and that's up to them. Okay, so a incomplete packet or one that's perceived to be incomplete by the buyer is in fact allowed. It's the best way to say that. Okay. And if no packet is received, the right to cancel obviously is conclusively waived if not exercised before settlement. Pursuant to 55.1-1808, and for the purposes of this paragraph, ratified sales contract includes any addenda to this contract. For delivery of the packet or notice of non-availability of the packet, the buyer prefers delivery at, and you usually put the buyer's name here, and I would put my name there as well, because I want to make sure if they only have 3 days to review it, that they have in fact seen that it has come in email or by hard copy. Okay, so one of the things is that in this paragraph, you have to make sure that if you are the seller, that the packet has been received. Okay, so delivery is constituted when the other side acknowledges receipt, right? So that's a little bit different than the normal delivery. So when your client gets that packet, or you're the seller, you're on the seller side and you're sending it to the buyer, you want to say to the agent and the buyer, whoever the delivery says in this paragraph, did you receive the packet? And they'll send you back an email that says, yes, we received the packet. And there starts the clock for the timeline of how long they have to review the packet. Okay. Virginia Condominium Act, which is pretty much the same. The seller represents that the property is or is not located, is not a condominium unit subject to the Virginia Condominium Act. Section 55.1-1990 of the Act requires the following contract language in the event of any resale of a condominium unit by an owner other than the declarant and subject to the provisions of subsection F and subsection A. The unit owner will disclose in the contract that 1, the unit is located within a development which is subject to the Condominium Act, and 2, the Condominium Act requires the seller to obtain from the unit owners association a resale certificate and provide it to the purchaser. The purchaser may cancel the contract within 3 days or up to 7 days if extended by the ratified resale contract after receiving the resale certificate or being notified that the resale certificate will not be available. If the purchaser has received the resale certificate, the purchaser has a right to request a resale certificate update or financial update in accordance with 55.1-1992 as appropriate, and the right to receive the resale certificate and the right to cancel the contract are waived conclusively if not exercised before settlement. Okay. For the purposes of this paragraph, ratified real estate contract includes any addenda to this contract. So for the delivery or notice of non-availability of the certificate, the buyer prefers delivery to, and as is here, my name, and the buyer is what I normally do. So next, we're going to talk about the property condition, okay? So we've already read in the paragraph here that pretty much everything, the property is as is, right? So your buyers are going to be making offers based on the condition of the property as they see it. So paragraph 10, we talk about that a little bit more, except as otherwise specified herein, the seller will deliver property free and clear of trash, debris, broom clean, and in, very important phrase here, substantially the same condition to be determined as of. Okay, substantially the same physical condition. You will hear that a lot, okay? And it's a very important phrase. As of the date of the offer or the date of the home inspection or other. None of us know what other is, but if someone comes up with it, let us know. So basically, you are making this contract and it's based on the date of the offer or the date of the home inspection. Why you might choose the date of the home inspection. The home inspection will give you a conclusive written document of the condition of the property at the time. So if the home inspection says, I have it in writing that the refrigerator was working and I get to the walkthrough and the refrigerator isn't working, that is not in substantially the same physical condition. So the seller would be required to make that repair. Okay, so that's why you might want to do the date of home inspection. Seller will have all utilities and service through the settlement. Buyer and seller will not hold broker liable for any breach of this paragraph. Buyer acknowledges that except as otherwise specified in this contract, property, including electrical, plumbing, existing appliances, heating, air conditioning, equipment, and fixtures will convey as is in its as is condition as of the date specified above. Okay, so if the air conditioning is working on the date of offer and you get to the walkthrough and the air conditioning isn't working, then again, the seller would be responsible for that. And this is where you're going to specify, we're going to have home inspections or we're not. We're going to have a home inspection contingency or we're not going to have a home inspection contingency. This contract is contingent upon home inspections and other inspections of the property, addendum attached, right? Or the buyer waives the opportunity to make this contract contingent upon home inspections and or other inspections of property. If this contract is contingent upon home inspections and other inspections of property, seller will provide broker, buyer, and inspectors retained by buyers, here it is again, reasonable access to property to conduct home inspections and other inspections of property. Okay, one of the things you have to tell your buyers, a lot of times they'll be like, well, I want to go in and measure and, my parents are coming to town and I want to show them the house. And you have to remember the sellers are also moving, right? So it's a major inconvenience to ask to come over multiple times to the home. And quite frankly, the sellers are not required to allow them in. They are, however, here required, as it says, to provide access, reasonable access for inspections with inspectors, right? If this contract is not contingent upon home inspections and or other inspections of property, seller will not provide access, okay? So if there's no home inspection, there's no access. They need to know that right away. Again, I'm sure it'll come up. Buyers want to show their parents or they want to take measurements or they want to do something. The seller is not required to provide them access to anyone for the purpose of conducting inspections except for walkthrough inspections as provided below. However, if checked, okay, so a lot of times we've had these people waiving home inspections, and yet they want to have a home inspector come through before they buy the property. And why might they want to do it? Well, they may find something major with the property, and they might decide, I want to walk away from this. I'm happy to give them my EMD to not be in this situation anymore. Or I'm happy to negotiate the EMD with the sellers to walk away from this deal. Okay, so this is where you're going to manage that. However, if checked, the seller will provide broker, buyer, licensed, if applicable, professional insured inspectors retained by buyer, reasonable access, again, reasonable access to property to conduct home inspections and or other inspections of property beginning on, and you would put a date there, 1 week after ratification and ending on 1 week before settlement. Okay. Now you might use other dates, you might specify dates, but that might be a reason that you want inspections. Let's just say your client thinks, I don't like the way this looks. Well, then let's put in an inspection period, even though you're waiving the home inspection. Okay. So it's always good to have multiple conversations with buyers. You always want to be informing them. They're the ones that need to make the decisions, but it's always good to explain every nuance here, like I am to you, so that they understand what their rights are. And the other thing is, a lot of people, no joke, buyers think that they should be able to, once they're in a ratified contract, just walk into the home whenever they want. That's not the case. Regardless of whether this contract is contingent upon home inspections and or other inspections, seller will provide broker and buyer reasonable access, there it is again, to property to make walkthrough inspection within 7 days prior to settlement and or occupancy. Okay, so within 7 days of the settlement, the buyer can get reasonable access again to walk through and to make sure that the house is in substantially the same condition. From up here, substantially the same physical condition as of either the date of the offer or the date of the home inspection. Possession date, unless otherwise agreed to in writing, the seller and buyer will give possession of the property at settlement, including delivery of keys, mailbox keys, key fobs, codes, digital keys, if any. Seller will transfer exclusive control of any smart devices to buyer at settlement. If seller fails to do so, occupies the property beyond settlement, seller will be a tenant at sufferance of buyer and hereby expressly waives all notice to quit as provided by law. Buyer will have the right to proceed by any legal means available to obtain possession of the property. Seller will pay damages, any damages and costs incurred by the buyer, including reasonable attorney's fees. Okay, so if the seller decides not to walk away and not to leave the home when they're supposed to, this has happened in California. You can look up the case. The buyer then is able to do whatever is necessary to take possession of the property. And the seller will be responsible to pay any damages or costs incurred by the buyer for the attorney's fees. One thing to note here that's important is the delivery of the keys, right? The biggest issue is the mailbox keys. No joke, just you want to make sure you have the mailbox keys, because I can tell you it's really a pain to get the mailbox keys. The condo association doesn't have the mailbox keys. The post office has the mailbox keys. And when the mailbox keys are lost, the rightful owner of the property has to go to the post office, fill out a form, pay a fee, and somewhere between 3 to 6 weeks later, the keys will arrive. Okay. It needs to be rekeyed, relocked, the whole 9 yards, and it's the post office that's doing it. And the seller will, of course, be responsible for the fees incurred as a result. So keep those mailbox keys and know where they are. Utilities, major systems, water supply. In most instances, we have public, hot water, oil, gas, electric, other, air conditioning, oil, gas, electric, other, heating, the same, sewage, public, or septic. So all of these things can be identified on the tax record that we talked about earlier. All right, so what is a personal property and what is a fixture that's included in the sale of this contract? Property includes the following personal property and fixtures, if existing: built-in heating and central air conditioning equipment, plumbing, lighting fixtures, sump pump, attic fans, lighting fixtures. Take grandma's chandelier down before the house goes on the market. Inevitably, the buyer will want it and the seller will want to take grandma's chandelier with them, and it'll be a major drag out fight over a chandelier. Just if they have things in there they want to take with them, just get them out of the house. Sump pump, attic, exhaust fans, storm windows, storm doors, screens, installed wall-to-wall carpeting, window shades, blinds, window treatment, hardware, smoke and heat detectors, antennas, exterior trees and shrubs, unless otherwise agreed to in writing, all surface or wall-mounted electronic components do not convey, okay? So the TV does not convey. However, all related mounts, brackets, and hardware do convey. Okay, so when we went into, smart TVs and flat screen TVs, there were knockdown, drag out fights about the huge holes left in the wall by the mounting equipment that people would take out of the home for those TVs. And so now those things are fixtures. The contract has specified that, and they need to be left behind. Smart home devices, very important to tell your sellers. They all want to have a Nest thermostat. They all want to take it out and take it with them. Smart home devices installed, hardwired, or attached to personal property or fixtures conveyed pursuant to this paragraph, including but not limited to smart switches, smart thermostats, smart doorbells, and security cameras. Smart devices do convey unless otherwise agreed to in writing if more than one of the item. Yeah, do convey. Okay, so unless otherwise agreed to in writing, if more than one of an item conveys, the number of the item is noted. Okay, so this used to be a yes/no checklist. Now it's just a yes checklist with a line. If there are 2 refrigerators, you're going to want to put in 2. Okay, if there are 2 refrigerators and your client is only taking one, make sure it's specified which one, because I guarantee you the really nice refrigerator in the kitchen versus the garage refrigerator is going to become an issue if only one refrigerator is checked there and there are actually 2 in the home. I have heard of people taking out the really good refrigerator and leaving behind the really bad garage refrigerator. And because it wasn't specified, they had the right to do that. Okay, so this is a paragraph where you can lose a lot of money very quickly. Notice there's no discussion about wine fridges here. Wine fridges can be built in and they can also be freestanding. They can be removed very easily. If there's a wine fridge, I would definitely put in here the specification of the wine fridge either staying or going. If there's anything else on the list that is not there, you're going to add those in on other conveyances. If there's anything that is not going to convey, you're going to put that in the does not convey. Okay. Fuel tanks. We don't have a lot of fuel tanks anymore. Everything is, in an HVAC system, but if there are fuel tanks, this is where you would specify if they're leased or they're owned with the property. Any other leased items or services, lawn contracts, security system monitoring, and satellite contracts do not convey absent an express written agreement by the buyer and seller. Okay. Paragraph 14. Okay, this is about people, foreign sellers who are selling, have property here and are from another country. There are some people that work in the United States from another country that are here for government orders or through their government, and they are exempt from this. So the seller is or is not a foreign person as identified by the Foreign Investment in Real Estate Property Tax Act, FIRPTA. If seller is a foreign person, buyer may be required. Remember now here, it says the buyer may be required to withhold and pay to the Internal Revenue Services up to 15% of the sales price on behalf of the seller and file an IRS form, which includes both seller and buyer's tax identification numbers. The parties agree to cooperate with each other and settlement agent to effectuate the legal requirements. If seller's proceeds are not sufficient to cover the withholding obligations under FIRPTA, seller may be required to pay at settlement such additional certified funds necessary for the purpose of making such withholding payment. Okay, so if someone is not here and they're not working for a government and they've just invested or they've lived in this in the United States, they may be required to pay 15% of the sales price. Okay, and if they don't, it ends up being the buyer's responsibility. So this is something that's important and that you need to know about. I actually did have a client who was a foreign person who was working here for the benefit of a government in government service. And as a result, we did have to get him an attorney who filed all the necessary paperwork. He was a seller. So that he didn't have to pay the 15%. So it is a legal process and there is paperwork that needs to be filed, something to be aware of, and you should know that, okay? Smoke detectors. Seller will deliver property with smoke detectors installed and functioning in accordance with the laws and regulations of Virginia. So the laws and regulations of Virginia specify one smoke alarm per level of the house. They recommend, but don't require, one in every bedroom. Lead-based paint housing. Seller represents that any residential dwelling at the property were or were not constructed before 1978. If the dwellings were constructed before 1978, then unless exempt under 42 U.S. C 4852D, property is considered target housing under the statute, and a copy of the seller disclosure and acknowledgement of information on lead-based paint hazards has been attached and made part of the contract as required by law. Buyer does or does not waive the right to a risk assessment or inspection of the property for the presence of lead-based paint and or lead-based paint hazards. If not, a copy of the sales contract addendum for lead-based paint testing is attached to establish the conditions for lead-based paint risk assessment or inspections. In all my years of doing real estate, most buyers waive that, okay? Unless you're going to eat paint chips and the paint chips contain lead. The lead is not as much of a hazard as it used to be. Most of it has been encapsulated since 1978. And this is just a disclosure that requires a lot of paperwork, and we have to give them, lead-based paint brochures and the whole 9 yards. So it's part of the contract, and so we do it. Wood destroying insect inspections, none. The buyer at buyer's expense or seller at seller's expense will furnish a written report from a licensed pest control firm dated not more than 90 days prior to settlement. WDI report showing that all dwellings and or garages within property, excluding fences or shrubs, not abutting garage or dwellings, are free of visible evidence of live wood destroying insects and or free from visible damage. If WDI report recommends treatment and or repair, seller will provide buyer, broker, and any representative of licensed pest control firm selected by the appropriate party above reasonable access, there it is again, to the property to perform the inspections, treatment, and or repair. Okay, so this is an important sentence. Any treatment and or repairs for damage identified in the WDI report. Okay, so you need to have a report from the inspector, will be made at seller's expense, and seller will provide written evidence of such treatment and or repair prior to the date of settlement, which will satisfy the requirements of this paragraph. Okay, so in the WDI report, the inspector has to say what the treatment will be and what damages need to be repaired in order for the seller to then pay for it and take responsibility for it. Unless the parties otherwise agree in writing, all treatment and or repairs are to be be performed by a contractor licensed to do the type of work required. All right. Home warranties. So we have a couple home warranty companies we work with. They're on our business affiliation document and they change frequently. So definitely check which ones we have a relationship with at the moment. I have now forgotten myself. So you're going to, if you're a seller, one of the nice things is to provide a home warranty so that the buyer does not have to worry about making any repairs in the first year of ownership. Okay. So if something goes wrong, they just call the home warranty people and they pay somewhere between $50 to $100 deductible and they take care of anything that needs to be fixed. So it's a nice little selling marketing point. Damage or loss. The risk of damage or loss to the property by fire, act of God, or other casualty remains with the seller until settlement. Okay, if we have a hurricane and windows are blown out, it's on the seller to fix that. So title. Buyer will promptly order a title report as well as any required or desired survey. I do a lot of work in Old Town. I always get a title report. I always get a survey. It's just not worth arguing about. You know, something could come up, you don't know, people get divorced, you know, ex-husbands and wives want to lay claim to property that maybe they have a claim to or they don't have a claim to. There are just so many things. So fee simple title to property and everything that conveys with it will be sold free of liens except for any loans assumed by buyer. Seller will convey title that is good, marketable, and insurable. Okay. It's an important point. The seller will convey a title that is good, marketable, and insurable with no additional risk premium to buyer or non-standard exemptions. In case action is required to perfect the title, such action must be taken promptly by the seller at the seller's expense. Title may be subject to easements, covenants, conditions, and restrictions of record, if any, as of date of ratification. Seller will convey property by general warranty deed with English covenants, title deed. The manner of taking the title may have significant legal tax consequences. One of the things I ask buyers is, are you legally married? A lot of people say they're married and they're actually not legally married. So you just want to say to them, listen, I don't need to know if you're legally married or not, but if you're not, you need to talk to the settlement agent because it might change how you want to take possession of this property together. Buyers advised to seek the appropriate professional advice concerning the manner of taking title. Seller will sign such affidavit, lien waivers, tax certification, and other documents as it may be required by the lender, title insurance company, settlement agent, or government authority, and authorized settlement agent to obtain payoff or assumption information from any existing lenders. Unless otherwise agreed to in writing, seller will pay any special assessments. Okay, so let's say your buyer is buying a condo and they have a special assessment that's on the books. The seller is responsible for that and will comply with all orders or notices of violations of any county or local authority, condominium owners association, homeowners or property owners associations, or actions in any court on account thereof against or affecting property on settlement date. Broker is hereby expressly released from all liability for damages by reason of any defect in title. Okay. So if the homeowners association, a lot of times the homeowners association will say, oh, your door is not the right color, you got to paint your door. Seller's required to do that. It's usually something a little like less innocuous, like the paint on your trim is peeling, you need to fix that. So, and then that would fall to the seller. Notice of possible filing of mechanics liens. Code of Virginia section 43-1 permits persons who have performed labor or furnished materials for the construction, removal, repair, or improvement of any buildings or structure to file a lien against property. This lien may be filed at any time after the work is commenced or material is furnished, but not later than the earlier of 90 days from the last day of the month in which the liener has performed work or furnished materials, or 90 days from the time the construction, removal, repair, or improvement is terminated. An effective lien for work performed prior to the date of settlement may be filed after settlement, and legal counsel should be consulted. Okay, so let's say we go to settlement, your buyer gets the property, and then this lien pops up. We can't get involved in that. They need to seek legal help. Fees for the preparation of the deed, a portion of settlement agent's fee billed to the seller, cost of releasing existing encumbrances, seller's legals fees, and any other proper charges assessed to seller will be paid for the by the seller. Fees for the title exam, except as otherwise provided, survey recording, and including those for any purchase money trust, and that portion of the settlement agent's fee billed to the buyer, buyer's legal fees, and any other proper charges assessed to buyer will be paid by the buyers. Fees to be charged will be reasonable and customary for the jurisdiction in which the property is located. Grantor's tax, as well as regional congestion relief tax, which is a lot of money. WMATA capital fee, which is applicable in the city of Alexandria, Arlington, Fairfax, Loudoun, and Prince William counties, and all cities contained within will be paid by seller. Buyer will pay recording charges for deed and any purchase money trusts. Okay. Seller irrevocably instructs the settlement agent to pay compensation, broker's fee at settlement as set forth in the listing agreement, and to disperse the compensation offered by the listing brokerage to the cooperating brokerage in writing as of date of the offer, and for the remaining amount of broker's compensation to the listing brokerage. Okay, so this is how, you know, the fees are distributed to the brokerages. It's already contained within the contract of how those fees will be distributed. Paragraph 24 is about adjustments, right? So if your settlement is in the middle of the month, you do not want to pay that full month of taxes. So rents, taxes, water, sewer charges, condominium units association, homeowners, property owners association, regular periodic assessments, if any, and other operating charges are to be adjusted to the date of settlement. Taxes general and special are to be adjusted according to the most recent tax bills for property issued prior to settlement day, except that recorded assessments for improvements completed prior to settlement, whether assessments have been levied or not, will be paid by seller or allowance made at settlement. If a loan is assumed, interest will be adjusted to the settlement date, and buyer will reimburse seller for existing escrow accounts, if any. Okay. Paragraph 25 is about attorney's fees. Okay, so it's all about everything is fine until somebody breaches a contract, right? So here we are in paragraph 25 about any sort of breaches. If any party breaches this contract and non-breaching party retains legal counsel to enforce its rights hereunder, the non-breaching party will be entitled to recover against the breaching party, in addition to any other damages recoverable against any breaching party, all of its reasonable legal expenses incurred in enforcing its rights under this contract, whether or not suit is filed, and in obtaining and enforcing or defending any judgments related hereto, should any tribunal of competent jurisdiction determine that more than one party to the dispute has breached this contract, then all such breaching parties will bear their own costs unless the tribunal determines that one or more of the parties is the substantially prevailing party. So if you're there's dispute and you're the substantially prevailing party, then your attorney's fees will be covered. In which case, any such substantially prevailing party will be entitled to recover from any of the breaching parties, in addition to any other damages recoverable against any breaching party, all of its reasonable legal expenses incurred in enforcing its rights under this agreement, whether or not suit is filed, and in obtaining, enforcing, and defending any judgment related thereto. Okay. So if you do something wrong and the other side has to come after you legally and you're found to have done something wrong, then you are paying their legal fees. In the event dispute arises resulting in the broker, as used in this paragraph to include any agent, licensee, or employee of broker, being made to a party to any litigation by buyer or seller, the parties agree that the party who brought the broker into litigation will indemnify the broker for all of its reasonable legal expenses incurred unless the litigation results in a judgment against the broker. Okay, so if we have to obtain an attorney and we're brought into a court and the other side is found at fault, then they pay the attorney's fees. All right, if buyer fails to complete, we're talking about default now. If buyer fails to complete settlement for any reason other than default by seller, buyer will be in default, and at the option of seller, deposits may be forfeited to seller as liquidated damages and not as a penalty. Okay, so like I said to you earlier, if there's an inspection that you have and the property is not contingent on an inspection and your client finds something they don't feel comfortable with, right here it says deposits may be forfeited to the seller as liquidated damages and not as a penalty. Okay, so that's an agreement between buyer and seller that we're going to go into this and we're going to use the EMD as damages. In such event, buyer will be relieved from any further liability to the seller. Okay, so if the seller agrees to take the EMD or a portion of it as liquidated damages, that's the end. There is no further process for them to go after anything else in terms of funds. Buyer will be relieved from further liability to seller. If seller does not elect to accept deposit as liquidated damages, deposit may not be the limit of the buyer's liability in the event of a default. Okay, so the buyer and seller knowingly, freely, and voluntarily waive any defense as to the validity of liquidated damages under this contract. So basically what it's saying is if you guys agreed to use the EMD as damages, there is nothing further, even if their damages are more, the seller can do. The agreement has been made. They're going to accept the EMD as liquidated damages and nothing further can happen. Buyer and seller knowingly and freely, voluntarily waive defenses that are liquidated. Okay, I already got through that. Including seller's option to elect liquidated damages or pursue actual damages, or that such liquidated damages are void as penalties or are not reasonably related to actual damages. If either seller or buyer refuses to execute release of deposit when requested to do so in writing, and a court finds that such party should have executed the release, the party who so refused to execute the release will pay the expenses, including without limitation, reasonable attorney's fees incurred by the other party in the litigation. I have one where the buyer decided they did not want to buy the property and they did not want to agree to release the EMD. So the EMD is just sitting and waiting. At some point, the seller will probably do something to rectify that situation. 1 minute, please. Sorry, I just have to text my son. Property condition, various inspection services and home warranty insurance programs are available. Broker is not advising the properties as to certain other issues, including without limitation, water quality and quantity, including but not limited to lead and other contaminants, sewer or septic or soil condition, flood hazard areas, possible restrictions of the use of property due to restrictive covenants, zoning, subdivision, or environmental law easements or other documents, airport or aircraft noise, planned land use, roads or highways and construction materials and or hazardous materials, including but without limited flame retardant treated plywood, radon, urea, formaldehyde foam insulation, mold, polybutylene pipes, synthetic stucco, underground storage tanks, defective drywall, asbestos, lead-based paint. Information relating to these issues may be available from appropriate government authorities. All right, B, legal requirements. All contracts for real property must be in writing to be enforceable. We all know that. We had that drilled into our heads during licensing. Financing, mortgage rates, and associated charges vary with financial institutions, so the buyer has the opportunity to select the lender and the right to negotiate the terms and conditions. Broker, buyer, and seller acknowledge that the broker is being retained solely as a real estate agent and not as an attorney, tax advisor, lender, appraiser, surveyor, structural engineer, mold or air quality expert, home inspector, or other professional service provider. Broker may from time to time engage in the general insurance, title insurance, mortgage loan, real estate settlement, home warranty, and other real estate business services. Therefore, in addition to the broker's fee specified herein, broker may receive compensation related to other services provided in the course of this transaction pursuant to the terms of a separate agreement / disclosure, and that is our business affiliation agreement, which we provide to everyone, right? Property taxes, believe it or not, your property tax could substantially increase following a settlement. And I would caution buyers, it almost always does go up. Property insurance, obtaining property insurance is typically a requirement of the lender in order to secure financing. Insurance rates and availability are determined in part by the number and nature of claims and inquiries made on a property's policy, as well as the number and nature of claims made by a prospective buyer. Okay, so if there have been a lot of claims against a home for property insurance, and the best way, the best example I can give you is, say, in Florida, where there are a number of hurricanes and lots of insurance claims. Obviously, the insurance is going to be higher if there have been multiple claims on a property. Title insurance, buyer may at buyer's expense purchase owner's title insurance depending on the particular circumstances of the transaction. Such insurance could include affirmative coverage against possible mechanics and material men's liens for labor and materials performed prior to settlement, which, though not recorded at the time of the recordation of the buyer's deed, could subsequently be recorded and would adversely affect buyer's title to the property. The coverage afforded by such title insurance would be governed by the terms and conditions thereof, and the premium for obtaining such title insurance coverage will be determined by its coverage. Buyer may purchase title insurance at either standard or enhanced coverage rates. So basically, you can get whatever level of title insurance you deem necessary. So in paragraph 29, we have a bunch of definitions here, what ratification means, what an appraisal means, what days means. Days are calendar days unless otherwise specified in the contract. All references to time of day are Eastern time zone. For the purpose of computing time periods, the first day will be the day following delivery, and the time period will end at 9 p.m. on the day specified. Okay, it's 9 p.m. It's not midnight. Jim Lyons and I have a difference of opinion on this, so let's not tempt it. I say 9 p.m. for the home inspection deadline, right? So if you want to walk based on a home inspection, you got to get that home inspection report in by 9 p.m. and the void. Legal expenses, notices, buyer and purchaser may be used interchangeably. Seller subsidy is a payment from the seller towards the buyer's charges, okay? Time is of the essence, paragraph 30. Time is of the essence just means that we need to follow all of the timelines in the contract. Okay, so if there are things that say, you know, you have 3 days to review the condo association docs, then you have 3 days to review the condo association docs. Paragraph 31 is to disclose if any of the parties to the sale are in real estate. The parties acknowledge that Gina Baum is an active or inactive real estate agent in Virginia and is either the buyer or the seller or related to one of the parties in the transaction. Okay, entire agreement. This contract will be binding upon the parties and each of their respective heirs, executors, administrators, successors, and permitted assigns. The provisions not satisfied at settlement will survive the delivery of the deed and will not be merged therein. This contract, unless amended in writing, contains the final, and like I said earlier, the entire agreement of the parties, and the parties will not be bound by any terms, conditions, oral statements, warranties, or representations not herein contained. The interpretation of this contract will be governed by the laws of the Commonwealth of Virginia. This contract may be signed in one or more counterparts, each of which is deemed to be an original, and all of which together constitute one and the same instrument. Documents obtained via facsimile machines will also be considered as originals. Typewritten or handwritten provisions included in this contract will control all pre-printed provisions in conflict. Assignability. So this contract may not be assigned without written consent of buyer and seller. The buyer and seller agree in writing to an assignment of this contract. The original parties to this contract remain obligated hereunder until settlement. Okay. So even if what that says is even if the contract, you assign that contract to someone else and all the parties agree, that contract remains the original party's contract until it's settled. Additions. All of this is important. Remember, I said everything must be contained in the four corners of the contract. So here is where we have all our addenda and what's going to be contained in the four corners of the contract. So the following forms, if ratified and attached, are made part of this contract. This list is not inclusive of addenda that may need to be attached. Okay, so it may not be all inclusive. There may be other addenda. Home inspection, lead-based paint, contingency and clauses, pre-settlement occupancy, residential property disclosure, FHA home inspection notice, conventional financing. Here is the extension review period for condominium resale certificate or property owners association disclosure packets. Okay, so there is a separate addendum that you can use if your client thinks that they need 7 days rather than only 3 days to review the condo association docs and the HOA docs. New home sales addendum. I haven't found that addendum very helpful at all. You probably won't use it. Escalation addendum we do use, and you should make yourself familiar with it. It's a little confusing. Private well and or septic inspection, post-settlement occupancy, lead-based paint disclosure, VA, FHA, USDA financing addendum, addendum of sale. That would just be like an addendum that we attach, right? So we have the ability to use an addendum, and if we have an additional something else we want to include in the contract, we would check that box or other, and you would put in another addendum that you are specifying. Okay. The box, date of ratification. Date of ratification is when all of the documents are signed. There's a meeting of the minds, and we put that date in. We want that date in there because it's how we determine the time is of the essence, right? When all of our deadlines are going to be required to be met, right? So that's why we need the date of ratification. We've got the party signatures here. It's always great for me as a broker if you have all this completely filled out. If ever there's an issue and I need to call the broker on the other side, what I will do is I can look at this. I most certainly review all documents before I speak to another brokerage. So it's important that we have all this completed and filled out. Any questions? Okay, I think that's the fastest I've ever done it.
You did
An
well.
hour and 28 minutes. I know it's a lot. It's a lot. And you want to know what's interesting is I think the office is also going to have some of the settlement companies probably come in once a quarter and do a sales contract review. And I always go to them because
Yeah,
you learn
that's
something new
regular.
you learn
Yeah.
something new every day, you
Yeah.
know, and like I said, whenever there's a question or a concern, the first thing I do is pull up the document and I have to reread it. You know, every circumstance is different.
Yeah.
And so you can never read this document enough.
Right. I agree.
Yeah,
So much.
you're so welcome. Anyone else with any questions?
No, just thank you, Gina. Appreciate it.
Oh, you're so welcome anytime. And so I'll do this class, I think, again in April, and we've spread out all the offices are doing different classes. So be on the lookout for them. It's really exciting because, you know, Arlington's doing it a little differently from Tyson's. And so we'll have a rotation quarterly of different classes. So I hope that's helpful.
Jeez.
Yeah,
Hi,
thank you.
good evening. I do have a question. You might have went over this in the beginning. I was a couple of
All
minutes late.
No
But
problem.
how do you retrieve this contract? Where is this located?
So it's in command, in DocuSign. And so if you take, you know, the command class, all of the documents are available in there in DocuSign.
Okay, thank you.
You're welcome. All right. Have a great day.
All right, bye-bye.
Thank you, you too.